Good afternoon, participants. I'm
Good
Anil
afternoon,
Goel,
everyone. Sorry.
and I have with me today Advocate Sanjay Gupta. Advocate Sanjay Gupta is the founder director of AAA Capital Services Private Limited, the company which is engaged in SARFAESI practice, and our role is enforcement of security interest. The Sanjay Gupta is the overall in charge for this part of the business of AAA Group. He is presently managing about 198 human resources associated with this SARFAESI business on full-time basis. And we also have CA Ankit Goel, who is also a founder director of this company. So the format of today's webinar again would be a lot of discussions, sharing of experiences by Advocate Sanjay Gupta, and also some of the general managers of AAA Capital Services in between, because practically what is happening at field level, that is also very, very important for all the participants to understand where the delays are happening, where the some kind of non-compliances are being repeated, and the borrowers are taking advantage of this. So presently the focus is entirely on the on those participants who are engaged in enforcement of security interest, sale of assets under SARFAESI Act, and not for providing remedies to borrowers. So this webinar is primarily for all those who are engaged in enforcement of security interest, recovery of bad loans through SARFAESI law, by sale of assets, by taking possession. So this is the webinar for those. Just to give you a recap, we had chapter 1 and chapter 2 in the last series of webinars. Chapter 1 was focused on the SARFAESI law. Chapter 2 was an overview of Insolvency and Bankruptcy Code, and also a comparison between the SARFAESI law and IBC law, effectiveness of it, and based on the experiences of 27,000 cases that we are handling, we analyzed our experience into 6 categories, and it was shared with the participants, like in what cases the IBC would be beneficial, and in what all cases SARFAESI would be beneficial. So what we understand as of now, that even if the Insolvency and Bankruptcy Code would be suspended for maybe up to 1 year, and it is not sure like on what defaults it would be extended. That definition of default we are still awaiting. However, the bankers, the lenders in the country would have only 3 options available. One, of course, would be very, very prime, that would be SARFAESI, because the SARFAESI is applicable to all kinds of entities, may it be proprietorship, individual, partnership, HUF, it is applicable to all private limited. However, this insolvency is only applicable to private limited companies and LLPs. The third option would be available, that may be some kind of restructuring which the RBI might announce, or as per the RBI circular dated 7th June 2019. So these are the only 3 options that would be available for handling bad loans. So while we are saying so, I think I would invite Advocate Sanjay Gupta. What should be the focus of our presentations today, and how do you feel that the SARFAESI law would SARFAESI law would be kind of perform in the next 1 or 2 years, or even or in the long run?
Good afternoon, sir. Good afternoon, everybody. Good afternoon, each and every audience for this beautiful presentation. As sir said that this is our series going on. इससे पहले अभी हमने 2-3 सीरीज वेबिनार किए हैं. आज का जो हमारा टॉपिक है कि डिले, अभी जो SARFAESI में डिले हो रहे हैं वो किस तरीके के रीजन हो सकते हैं, और किस तरीके से हम प्रैक्टिकली पिछले 16 साल के अंदर जो करते आए हैं उसके हिसाब से क्या इसको हम मैयर एज ए कंपनी, एज ए एनफोर्समेंट एजेंट, एज ए रिकवरी एजेंट हम क्या मैयर लेते हैं जो प्रैक्टिकली बैंकर्स को फ्रूटफुल हुआ है? तो अभी जैसे मॉरिटोरियम कोविड-19 का बहुत बड़ा इम्पैक्ट है पूरी इकोनॉमी में, सरफेसी में भी, इंसॉल्वेंसी में भी। इंसॉल्वेंसी में तो जैसे 1 साल का फाइनेंस मिनिस्टर ने कह दिया कि 1 साल नए केसेस हम सेक्शन 7-9 में नहीं एडमिट करेंगे। सरफेसी में भी अभी जैसे 3 मंथ्स का मॉरिटोरियम था, अभी शायद उसमें 6 मंथ्स का हो गया कि 6 इंस्टॉलमेंट्स वो एक जो बोरोवर है दैट कैन डेफर द पेमेंट ऑफ 6 इंस्टॉलमेंट्स। तो उसके हिसाब से ऐसा लगता है सर कि जैसे अभी नए एनपीएस इस पीरियड के अंदर अप टिल अक्टूबर और नवंबर, अभी ये तो नए एनपीएस नहीं होंगे और अभी इस तरीके का ही है कि पुराने जो केसेस हैं उन पे कोई एक्शन लेने में बार है, अभी ऐसा भी नहीं आया है। तो पुराने केसेस आई बिलीव कि हो सकता है वो चलते रहेंगे। तो जैसे ही गवर्नमेंट को, अथॉरिटीज को, डीएम को, तहसीलदार, पुलिस अथॉरिटीज जो भी इन्वॉल्व हैं इसमें, तो उनको जैसे ही कोविड के प्रेशर से थोड़ा सा रिलीफ मिलेगा तो आई बिलीव दे वुड बी issuing orders. Police will be helping the banks to enforce the properties and recover the dues. So अभी in the near future 6 months to 8 months if I see, so अभी तो impact इसमें recoveries में banks को setback मिलेगा, लेकिन उसके बाद इसमें हम एक फिर दोबारा से recovery देखते हैं सर। इस तरीके से मेरे को लगता है कि अगले साल इसको हम आगे बढ़ेंगे और पूरा machinery or government authorities would be helping to enforce the securities under SARFAESI Act as well.
So Ankit, what is the present situation of the total participants? Like we know that we had how many registration we had this time?
We have a total of about 13. We had 1400 registrations for this session, and we have 564 attendees so far. And I will like to add that when everything else is a little uncertain, there is no uncertainty about the future of recovery under SARFAESI for banks. So I think the action will take time. Some borrowers will take time, and there might be a genuine need for moratorium in many cases. But where the bank chooses to exercise its mortgage, I think there is no bar, and I don't expect any bar to come in for SARFAESI action. Further, I believe that we need to take some feedback which has come in with that the feedback that a lot of our audience or a lot of participants today are English speaking participants. So we will have to keep a focus in speaking in English perhaps. That is one feedback that I would like to share with all the participants. So we can minimize the use of Hindi. Yeah, I think we should start. It's time.
So thank you, Ankit. All said and done, SARFAESI is going to exist in case we analyze all the judicial orders from Supreme Court. I think most of the issues have been settled. There have been various Supreme Court judgments, High Court judgments in this case. SARFAESI law is now can be considered as completely settled. This is the best recourse available with the lenders so far in all those cases where the assets are still assets, the company is not in operations, and the possibilities of resolution plan would be difficult. In all those cases, the SARFAESI would be the law which would be across the country, across the entities, across the class of assets, across the kind of assets. It would be applicable and it would be helpful in the for the recovery of the bank loans. Yes, one thing is very important is the availability of investment scenario, availability of buyers for the assets, may it be insolvency law or may it be SARFAESI law. Unless the buyers would be available, no recovery process can be successful, or no resolution process can be successful unless we have the buyers available. So creating buyers in the country, creating that kind of atmosphere in the country, like the kind of ease of doing business which the government is trying to do. If some investment is attracted from overseas, if the loans are disbursed to MSME, then only we would actually get the buyers under a SARFAESI law, because SARFAESI is primarily for MSME, and for MSME market the investment has to be promoted disbursement of loan credit delivery has to be improved, then only the success would be there. You can definitely get success in taking over the possession of the assets. You can cross all the hurdles of taking physical possession, taking DM, CMM orders. You can all reduce the timelines. However, nobody can control the timeline on account of the lack of or scarcity of customers. So with this, I think I can just move on to my uh, slides, and I would only say that is few of the slides I would only use only for a recap, only for a slight recap, very short recap, because see, whenever we are discussing any law, it is important that we should understand the basics of that law. So while we start, although the focus will remain the same as finding the hurdles, finding the errors, finding the reasons for the delay in recovery, but the basics of SARFAESI law would also be very important for all the participants to understand the basic subject and the detailed subject. See, the SARFAESI, as there has been lot many amendments in SARFAESI Act, and the last amendment that we have seen is the Security Interest Enforcement Amendment Rules 2018. And the amendment rules, and before that there was a very important amendment that was in 2020 itself, where this CERSAI was made, CERSAI registration was made compulsory. So present scenario that we have with us is, unless the charge on the property, unless the transaction is registered with CERSAI, that means central registry, the SARFAESI action cannot be taken. So all the banks must ensure that all the charges that they have created on any of the assets, before they take any SARFAESI action, they actually have to see whether the central registry has been informed and the transaction has been registered with the central registry or not. So that the latest transaction also, the latest amendment, which is the February 2020 amendment, also has assured that the priority of interest. So in case this central registry has registered a charge, thereafter even the charge by the statutory authorities would be a second charge. Once the lender's charge is registered with the CERSAI, then no other charge would have a priority over the lender's charge. That is a very welcome amendment, which actually happened only in February 2020. So this going forward, as we understand what we are, SARFAESI law is basically a combination of three laws, like as we discussed in the last chapter 2. That was the one is the regularization and monitoring of asset reconstruction companies. The second is enforcement of security interest. We would be dealing with enforcement of security interest. And then the third is the setting up and management of central registry. Central registry is completely activated and it is mandatory now for everyone. Now the central registry is open for the private transactions also. Everyone is advised to register the transaction with central registry, because that will actually have a lot more comfort when you are trying to enforce your security interest. So 2016 amendment is very important. A lot of situations were handled in 2016 amendment. 24th January 2020 amendment, which was effective, that was also a very important, where some sections were notified, and those sections are having impact of making the CERSAI as one of the very important precondition for enforcing your security interest. So we have already discussed constitutional validity of SARFAESI. We have already discussed, like, the SARFAESI law was originally available. This recourse was originally available with the banks, financial institutions, consortium of banks and financial institutions, asset reconstruction companies, and also for the debenture trustees. Later on, it was also made available to NBFCs. NBFCs also getting benefited from this SARFAESI action. And in fact, this was the NBFCs were notified as financial institutions on 5th of August 2016, and originally it was open for only those NBFCs who had assets worth more than 500 crores, whereas on 24th of January, the notification came and the amount of uh, the audited balance sheet, it was reduced. The assets worth 100 crore in the last balance sheet, and the debt is 50 lakhs and above. These are the two conditions. Earlier, the debt was 1 crore and above, and now it has been made as 50 lakhs and above. So now every NBFC can invoke SARFAESI in case the asset size of the NBFC is 100 crores and the individual loan which is supposed to be enforced is above 50 lakhs. So however, for everyone, for the banks and financial institutions, the limit is 1 lakh of outstanding. In case the outstanding is 1 lakh of rupees, the SARFAESI law is not less than 1 lakh rupees. The SARFAESI law is not applicable. Banks doesn't have the option to enforce SARFAESI. See, like this India Bull Housing Finance Limited versus Deccan Chronicle Holdings Limited, it was the very important judicial pronouncement given by the Apex Court, Supreme Court in 2018, and it was like for NBFCs, even if the loan, even if when the loan was given, the NBFC was not a financial institution, and they were at the time of notification of the financial institution, when the NBFCs were made part of the financial institution, all the existing loans, wherever, whenever it was granted, so the SARFAESI law was applicable on all the existing loans. It was not applicable to the new loans. It was applicable to all the existing loans also. So whenever we enforce SARFAESI enforcement, we need to first of all see whether the property that we have, that is the charge that we have, whether that is eligible to be enforced under SARFAESI law or not. So this is a little bit of a recap of what we discussed last time, but of course this has got a connection with the delays. So in case we start enforcing SARFAESI action on maybe pledge transactions, then we would be wasting our time, because the SARFAESI law is not applicable to pledge transactions. Pledge transactions are not enforceable under SARFAESI because the possession is already with the secured creditor, and the pledge assets can be sold without invoking SARFAESI Act. Pledge is governed by Section 172 of the Indian Contract Act, and it cannot be governed by SARFAESI Act. Hypothecation of various items like hypothecation of stocks, hypothecation of receivables, all these items which are basically movable items, and this is also called floating charge. On these kind of charge or these kind of hypothecations, the SARFAESI can be only invoked for sale after crystallization of the asset. Now, in case I suppose as a bank, if I have given a loan of 100 crores against stocks, and there is a floating charge on the stock, and the stocks of the company is 150 crores, and I have given facilities of 100 crores. So how do I enforce SARFAESI? Because the SARFAESI is all about taking possession and selling. So till the time I take possession of the entire stock or whatever stock that I could get hold of, and then only the SARFAESI law can be applied. So in case I don't get the possession, I cannot sell the asset under SARFAESI because the asset is already moving. It is movable asset. Unless it comes under my control, my custody, my security, and my then only it can be sold under SARFAESI Act. Yes, we can enforce security. We can enforce security interest for the purpose of taking possession of the stock, and the same is the situation for all other kind of hypothecation, which is called floating stocks. Mortgages, registered mortgages, like all these charges, hypothecation, assignments, all this is covered under SARFAESI Act. And now in the Amendment Act 2016, even the financial leases and the hire purchase also come under the purview of SARFAESI Act. So the finance leases and the hire purchase and the conditional sales also can avail the benefit of SARFAESI for recovery. Even in 2016, the on intangible assets also the SARFAESI is enforceable, because see, like probably the charge, when we create a charge on intellectual property rights, or any assignment of any trademark or any other copyright, that can also be enforced under SARFAESI, and the bank would be able to sell the intellectual property rights or intangible properties by invoking SARFAESI. Any licenses created on the property can also be sold. So all this can be sold in case the credit provided to enable the borrower to acquire the asset. So in case the bank or financial institutions is provided the credit to enable the acquire the proper asset, obligation to pay any unpaid portion of the purchase price, any obligation incurred, and license of intangible assets. So these are the kind of the borrowings. These are the kind of borrowings which would be covered under SARFAESI Act. So this is something which is specifically not enforceable under SARFAESI Act. So in case you have a lien, in case any banker has a lien on any goods, money, or security by any by or under the Indian Contract Act, such as bailment, margin money, earnest money deposit, lien on fixed deposit for providing loans, lien on shares for providing loans, factoring services, agents lien on principal's property. All these are sections 170, 171, 221 of the Indian Contract Act, and these liens cannot be enforced under SARFAESI Act. The lien under the Sales of Goods Act is also excluded specifically, and the lien under any other law for the time being, the liens are not to be enforced under SARFAESI Act. And for the liens, the permission of the borrower is required to sell the asset. However, whenever we see the loan against FDR, loan against shares, or the margin money for the stock exchange purposes, they already take as a part of the standard documentation a consent for sale of the securities. So with that pre-blank signed document, whenever there is any default in the case of lien, the lender or the person who has extended any kind of credit facility would be able to sell the assets on which the lien has been created. Specifically, the pledge under section 172, and in all the pledge cases, the lender has always a right to sell the security interest without taking any consent of the borrower. The pawning, pledge of mercantile agent, pledge of goods or loan, pledge of agriculture produce in silos, old godown system, all these are the examples of pledge system. Then subsequently, the specifically excluded items are Aircraft Act. I think nobody can enforce a security interest for capturing or for selling aircraft acts, for taking physical possession. Similarly, for merchant shipping. Similarly, for the Sales of Goods Act, right of unpaid sellers. So all this is the examples where the SARFAESI Act is not applicable. So by mistake, in case we enforce SARFAESI Act on all these security interest, on all these assets, or all these kind of charges or hypothecation, then it will be a wastage of time and the results would be zero. Any property where the value is less than 1 lakh of rupees, any security interest created on agricultural land, this of course is a very big issue. What is an agricultural land? However, the latest Supreme Court judgment is very, very important. I will come to that. This is very important that in case the total loan given is 1 crore and the balance is less than 20%, means less than 20 lakhs, then in that case the SARFAESI cannot be enforced. See, coming to the motor vehicles, like whenever we see a motor vehicle loan can also be processed under the enforcement of security interest can be enforced under SARFAESI Act, but then that would only happen once the possession of the motor vehicle is taken by the lender. It can also be taken under the Indian Contract Act with police help. Even the Arbitration and Conciliation Act also helps it, and through the court orders it can also be done. The Supreme Court has actually given one judgment in ICICI Bank versus Shanti Devi Sharma, And there were many things which actually were decided in that case by the Supreme Court regarding some kind of processes that has to be followed, the basic hygiene that has to be maintained by the recovery agents. Some kind of education was also stipulated, a course was stipulated. After that, it is because like capturing a motor vehicle, it has almost become very routine scenario. Then is the negative lien or mere restraint on property. Like whenever a loan is given or a security is taken by the lenders as a negative lien, a negative lien means that the person is restrained from selling that property. That doesn't mean that the SARFAESI is not applicable on this, because under SARFAESI the title is required, and in this case the title is not with the title of the property is not with the bank or not with the lender. So therefore the negative lien also cannot be enforced under SARFAESI Act. So agriculture land, of course, we discussed at length. There are so many judgments on the agriculture land we actually have to see. But the most important thing that I want to share with you is that this Indian Bank and others versus K. Papiridiyar and others. This is the 2018 Supreme Court judgment. In case we read it carefully, the classification of land in the revenue records as agriculture is not dispositive or conclusive of the question whether the SARFAESI Act does or does not apply. Whether a parcel of land was agricultural must be deduced as a matter of fact from the nature of the land, the use to which it was being put on the date of the creation of the security interest, and the purpose for which it was set apart. So when the interest is being created on any piece of land, maybe on a piece of land where a factory is supposed to come, it is very important that the character of the land has to be seen as on the date of the creation of charge. So whenever we create a charge on any land, the defaulter should not take the shelter of the agriculture land. We should take some undertakings from the lender, from the borrower, that this land is not an agriculture land, it is not being used for agricultural purposes. So that kind of undertaking will reduce a lot of litigation in future, and especially in those cases, in the case of greenfield plants, where the land acquired is agriculture land. Later on, the land will become an industrial land without even at times taking a CLU, conversion of land use. Still, it is very important that we should create some documentation at the time of creation of charge based on the Supreme Court judgment in the case of Indian banks and others versus K. Papiridiyar. In this case, the important concept is as on the date of creation of charge, what was the status and what was the use and what was the land set apart. It was set apart. In this case of Madras High Court in Parson Medical Plants Private Limited, it was held by the Madras High Court to ascertain the true character and nature of the land. It must be seen whether the land has been put to use for agricultural purposes for a reasonable span of time prior to the relevant date, and further whether on the relevant date the land was intended to be put to use for the agricultural purposes for a reasonable span of time or not. Now, in case we see that agricultural land is acquired, and after the acquisition of the land, the poultry farm is set up and the loan is taken, but then later on it is very difficult to say that this particular land was intended to be an agricultural land. So the intention at the time of taking the loan has to be declared that this land would not be an agricultural land after the land is taken, because mostly whenever there is a default, then most of the borrowers will actually resort to this idea that it is an agricultural land. Then we actually have to see what kind of loan was given for which the security interest was taken and for which the enforcement was being done now. So first of all, it is applicable to all kinds of loans or advances granted or granted to acquire granted or acquired as a financial asset. The financial asset here means like in case we acquire a loan and that is also covered. Debentures or bonds subscribed, guarantees given or letter of credit established, funds provided for acquisition of a tangible asset under financial lease, hire purchase, or conditional sale. This was added only in 2016. Funds provided for obtaining assignment or license of intangible assets, purchase of debt securities. So this, like in case we try to enforce SARFAESI on discounting of bills or bill of exchange or factoring services or transactions of pledge, pawning, pledge of goods, then the SARFAESI Act would not do anything except for the delay. And we have already, like as far as the DRT is concerned, DRAT is concerned, that all everyone knows that today we are focusing on. Of course, this is also one of the very big reason for the delay nowadays, that the capacity has to be created. There is a capacity constraint in debt recovery tribunals, and also in say the disposal of the applications are delayed. At times the banks are very active, but the court, because of the preoccupation, the decisions from the courts are very slow, and at times the stay which is given by the DRT, that has actually spoiled some of the image of SARFAESI law. See, I have experienced practically that most of the borrowers, they go to DRT for taking stay, and they also know that once the stay is granted, it would be absolutely 1 year time, and we would be able to enjoy the asset. We will be able to further milk the asset. Whatever is possible, we would be able to take it away. So that is the biggest reason for people to approach DRT, showing as if they are anguished, as if they are adversely impacted. In fact, their basic objective for filing an application to DRT is to take a stay, and then once the stay is taken, then it will continue for some longer period because of the capacity constraint of DRT. The capacity is also being augmented. The other part which is little negative here is in the individual insolvency and bankruptcy for one class of individual grunters is also with the DRT now. So the DRT has to handle SARFAESI Act. DRT has to handle now the Recovery of Debt and Bankruptcy Act. So the DRT also is handling personal grunter. So the DRT has actually become very occupied, and the delay also happens at the DRT end.
Mr. Rajneesh Chawla from SBI has a question, and I think I can ask him to state the question. I'm just unmuting you, sir. You can speak out. Sir, I've unmuted you, Mr. Chawla. Mr. Chawla, are we audible to you? So I will just dictate the question that he had put out. Mr. Chawla was asking that if the borrower has availed two credit facilities, one in individual capacity and the other as a proprietorship, having the same PAN number, of course, and one account of cash credit limit has turned NPA, so can we serve, he says, can we serve a notice under section 13(2) for both the accounts?
First of all, it is very important when the SARFAESI action can be initiated. First of all, the account has to be NPA, and in case there are two separate accounts, one is the account in the individual name, which can be a car loan, which can be a home loan, or which can be a separate shop, and that has a separate security, and then the other is a proprietorship concern that has a separate security. So if one loan is NPA and the other loan is not NPA, then you cannot invoke SARFAESI action in that part of the loan which is not NPA. So the SARFAESI action, it is very important that the account must be declared as NPA, and that security is a separately available security for that account. So in case we have a common security, so even for one NPA, then we can enforce the common security for our security interest.
So secondly, I think there's a slight confusion, and we can clarify that for jurisdiction for personal guarantors to CD, the jurisdiction is DRT wherever the proceedings against the company or against the CD have not been initiated in NCLT. And I think you can clarify on that also, that differentiation between NCLT and DRT for jurisdiction.
Yes, so far the insolvency law has been implemented for the personal guarantors to corporate loans. So there are two kinds of corporates. One corporate is where the insolvency is started against that corporate, and the other corporates are where the no insolvency has started against those corporates, and those corporates are already something which is under SARFAESI. They have been there in DRT, or they are not in DRT. So any one corporate whosoever is already under NCLT, so the personal guarantors to that loan would go to NCLT, and where the company, that the corporate is not under NCLT, all those personal guarantors will go to DRT. So there is a specific bifurcation into this. Why those should go to NCLT when there is no CIRP or liquidation is going on for that company. So in case the CIRP or the liquidation is going on for the company, then the guarantors also will fall in the same bench. So that's what is the law.
And another question from Mr. Ravi Bagri is associated with this question. His example is related to IBC, where he says that there is a CD under CIRP. The CD has taken a loan from a bank, and the bank has, of course, mortgaged a property belonging maybe residential property in the name of the existing directors that has been mortgaged, not the CD's property. So in that case, he says that but the corporate, the CD has given a guarantee even for the home loan that has been taken. So one, there is a loan taken in the name of the CD. One, there is a loan taken in the name of a top-up loan or a personal loan taken in the name of the directors. The mortgage property is the personal property of the promoters. This is the example, and he wants to understand that what can be the action under SARFAESI, and what will be the claim process in IBC for this kind of an example.
So one scenario which I would like to clarify here is that under insolvency, all those assets are covered which are owned by the corporate debtor, which are owned by the company, irrespective of the various collateral securities which are owned by the directors or relatives of the directors. The IBC is not applicable on those assets. So in case we are finding a resolution plan, we will only find a resolution plan for the assets of the corporate debtor, and not the assets owned by the directors or the relatives of the directors. So once maybe the loan has been taken, by the company on the security of that asset. Now, for example, that the company ABC is under insolvency and the company has taken 2-3 loans, and one loan is against a property which is owned by the director. Still, the claim would be received in the company, but that property which belongs to the directors, that would be enforceable under SARFAESI, but not enforceable under IBC. However, we are also trying in some cases to find a collective resolution plan where the personal properties and the corporate debtors properties are collectively being considered in a resolution plan, and we are trying to submit it to the NCLT for a collective solution, for a collective resolution. Because most of the properties are owned by the personals, and the loan is taken by the company. So the resolution which is available for the company is basically trying to settle all the personal properties of the directors also. So I hope it is clear. One, the IBC can only handle properties, assets owned by the company. Even IBC, while the IBC, CIRP or liquidation is going on, the personal assets of the directors or the relatives of the directors can be enforced under SARFAESI law. There is no moratorium on those assets, and there is no moratorium on the recovery from those assets. That is the well settled law now. So when we see, Ankit, when the SARFAESI action can be initiated, first of all, the borrower makes any default in repayment of the secured debts or any installment thereof, his account in respect of which the debt must be qualified as NPA, and the NPA would be considered as Banker's Book Evidence Act 1891 will prevail. As per the Banker's Book, in case the account is NPA, that will be considered as NPA. However, in the case of debenture securities, debt securities, NPA requirement is not there. So this is, see, why we are enforcing SARFAESI is because it actually gives power to the banks for enforcement of security interest without the intervention of any court, and also to sell the properties without the intervention of any court. So that is one reason that when this SARFAESI law started, it was introduced in 2002, and in 2003 a very significant judicial pronouncement was made by Honorable Supreme Court in the case of Mardia Chemicals. Mardia Chemicals, it was decided and was held by the court that since it is a very, very vast powers given to the bankers, and it was also considered that it can be seen that the bankers also can make mistakes in the entire SARFAESI law. There is no court involved. The bank can, any authorized officer like scale 4 and above officer can enforce security interest, can take the possession of the property and can sell that without the enforcement, without the intervention of any court. And this DMM or CMM order is also not a court, because see, this is not mandatory. In case the possession is available and possession can be taken by the bank other than without the help of CMM or DM, then there is no court involved, not for anything. It is only the bank taking a decision while sitting in the bank, and the property can be taken over, property can be sold. See, while this was being considered by the Supreme Court, it was constitutionally held as valid. However, it was also told that the entire process which is stated in the SARFAESI Act and the security enforcement rules must be adhered to, and any default, any hurriedness, any opportunity, any lack of opportunity given to the borrower would be considered as something which is totally undoable. So there has been judgments in the Supreme Court, like where some of the process was not completed by the bank, and even the entire process of acquisition, sale, everything was reversed by the Supreme Court or by the High Court or by the DRAT. So there has been so many judgments. So based on all these judgments, it has actually become a case where it has actually become a law with a lot of litigations. And the most of litigations are only and only on account of one part, that the bankers have made some kind of error, or the borrower has been able to make that or present that as an error, or the bankers has not kept some of the records, which is very, very important for showcasing the process, and the borrower has been able to take the advantage of that record keeping process. So the logic of the litigation, the logic of the errors, the delay, it is all and all is based on one concept, that the entire procedure, the rules has to be followed absolutely in the manner as it is written or as it is held by various courts. So in case of any kind of non-compliance, then there is a possibility of stay, there is a possibility of reversal of the entire process. So the basis is that all the procedures has to be complied with. So the entire process is how to keep the documentation. In case every action has been taken by the lenders and the records are missing, the bank will have to take all the actions again, because the DRT will immediately give stay in case the proof of process being adopted is not submitted to DRT, or there is a complaint by the borrower that this has not been done in my case, and this one part of the process is not done in my case. So that can easily be considered as non-compliance by the bank, and the entire process can be stayed. Then we also have to see whether the security interest is as per the definition, whether the secured creditor is eligible. Financial assistance also should pass the test definition. Then this, of course, SARFAESI Act is also very, very powerful, and the DRT has got all the rights. So now coming to the real subject of today. The real subject of the today is the detailed procedure that has to be followed by lenders, that has to be showcased by the lenders to DRT. For all these steps that I'm showing it as step 1, step 2, step 3, all the evidences has to be retained by the lenders, and if need be, it has to be presented before the court to satisfy the court that the entire process was taken, it was done, and it was complied with. So basis the entire, now from now on, the entire presentation is all about this, and also about Advocate Sanjay Gupta and one of the general managers or few of the general managers of AAA Capital Services who are engaged on day-to-day basis in enforcement of security interest would share their practical experiences, how the delay is happening in various SARFAESI cases. So the very first step, whenever the lender decide, whenever the bank, financial institutions, NBFCs, ARCs decide to take SARFAESI action for recovery of the loan, so the first and foremost is the enforcement of security interest. As I said, enforcement of security interest, when we say, then we must see whether the security interest is eligible, whether the bank or the financial institution is eligible, whether the category of the loan is eligible under SARFAESI Act. That's a primary theoretical aspect that you have to see before taking any action. Otherwise, after all the process even done meticulously, still based on the definition, that can be completely quashed later on by any court. So the first notice is called 13.2 notice, which is called 60 days notice, and the secured creditor give notice to the borrower in writing to discharge in full his liabilities to the secured creditor within 60 days. This is a very simple notice. And now what has happened is, like, over a period, over the various amendments, each and every format of the notice or various documents, the formats has been provided in the security enforcement rules. So there is no ambiguity. The format which is provided in the rules has to be filled up completely. It should not be kept blank, and complete records must be kept so that it is presented in a court whenever the need arises. In case not paid within 60 days, the secured creditor shall be entitled to exercise all or any rights under section 13.4. This is what is the notice, a very simple notice. And the contents of the notice should be like this: the authorized officer who is responsible, the content must be borrower detail, the amount payable by the borrower. So this was mentioned in the SARFAESI Act. Particulars of the secured assets intended to be enforced by the secured creditor. Notice to be issued by the authorized officer of the secured creditor. Now the notice is to be issued by not less than a chief manager of public sector bank or equivalent. Otherwise, for the in the case of NBFCs or in the case of private banks, it would be as specified by the board of directors of secured creditor. Any other person or authority exercising powers of superintendence, direction and control of business or affairs of the secured creditor. So this is what has to be recorded. The person who actually would be considered as an authorized officer, he would be he is duly authorized to take action. That kind of evidences has to be created. Maybe it's a resolution of board of directors, or maybe a resolution regarding the superintendence and directions and the control of the business affairs. So that evidences has to be kept. The notice must be complete in all respects, and it requires a transparency, principles of natural justice applicable for service of notice. Notice is only a demand notice and does not add any rights to the secured creditor. Effect of notice is also provided in section 13, subsection 13. The borrower, after the notice is given, after the notice under section 13.2 is given, borrower shall not transfer by way of sale, lease or otherwise any of the secured assets referred to in the notice without prior written consent of the secured creditor. Proceeding against guarantors is also possible. Now, this effect of this notice under section 13 was also handled, and it was also adjudicated by Madras High Court judgment, namely D. Ravi Chandran versus Indian Overseas Bank, that a notice under section 13.2 of the Act is really a show cause notice, and ordinarily this court does not interfere with show cause notice. The notice under section 13.2 of the Act by itself does not affect any right or liability of the borrower. Hence, challenge to the notice under section 13.2 of the Act is premature, since it is possible that the secured creditor may be satisfied with the reply of the borrower to the aforesaid notice and may drop the proceedings. So it was held many times by various courts. In fact, the borrowers, they had started taking the advantage of DRT, and they started going to DRT court even at the receipt of notice under section 13.2. So now it has been held by various high courts, and that section 13.2 notice has got no cause of action, and no kind of appeal is no kind of appeal or no kind of application can be made. Now, when we talk about this notice under section 13(2), the securities enforcement rules were made on this, and the entire process was mentioned in the rules. So the rule 3, sub rule 3 is applicable, and in case we see this carefully, the service of notice by delivery, including hand delivery, is possible, because it was not possible earlier. With the fact from 4th of November 2016, now the notice can be served by hand delivery also. Transmitting at a place where the borrower or his agent actually and voluntarily resides, or carry on business or personally work for gain. Address to the borrower or his agent empowered to accept the service. Now, how many modes of service? Registered post with an acknowledgement due, speed post, courier, fax message, electronic mail service by hand delivery. If the AO has reasons to believe that the borrower is avoiding the service or the service is not being done for any reason, then there is a mode given against that. So first and foremost is that the what we call is the affixing of the notice is concerned. Affixing of the notice is not mandatory. It is only required in case the other services of the notices are not acknowledged, and if there is any acknowledgement available with the bank regarding the service of the notice, and that acknowledgement is conclusive, then this affixing, which is called CESPA process, is not required. The CESPA process is there with the affixing the notice on the outer door or some other conspicuous part of the house or building in which the borrower or his agent ordinarily resides or carries on business. Publishing the contents of the demand notice in 2 leading newspapers, one in vernacular language, having sufficient circulation in that locality. So this is the CESPA process, where the borrower is a body corporate, the demand notice to be served at the registered office or any of the branches where the business is to be conducted. In case of multiple borrowers, notice shall be served on each borrower. The notice may invite attention of the borrower towards time available with him to redeem the secured assets. So the contents of the notice is also given. What is important here is to see how the notice has been made, how the contents of the notice is made, and how the same has been serviced. So this part has to be very clearly seen.
A very relevant question at this point in time. So some of our participants are asking that how do we serve the notice on email? Because traditionally, while there was no COVID, I think everyone was following the traditional route of sending it by alternative communications. So should it be on letterhead? Should it be digitally signed? What should be the way that this notice under 13(2) is served by email?
Whenever we talk about any notice which is served on electronic mail service, the electronic mail service, it has to make 2 things very sure: that electronic mail itself, if it has actually been transmitted, if it has been sent through an official mail of the bank, then it would be considered as a mail which is properly given. And on an email, it is not required that it should be digitally signed, because this is a notice only. This doesn't require a digitally signature, because this is not a document, this is a notice, and it is to be sent from an email which is an official email of the bank. And like in most of the cases, since we have the experience that the borrowers are taking the advantage of DRT and they would like to highlight some or the other deficiencies, so most of the bankers, they actually try to do multiple servicing of the notices. They would send it by registered post also, speed post also, courier also, electronic mails also, and in case possible, hand delivery. So most of the lenders, they would actually resort to the multiple sources. So as far as the email is concerned, one, that the email doesn't require any digital signature. It only should go from the official email ID of the bank. Secondly, it actually should go to the mail ID, which is an official mail ID of the borrower, and that has to be evident that that is the official mail ID of the borrower. Borrower must have been communicating with the bank through that email, or that email must have been mentioned in some of the documents of the bank, which is duly signed by the borrower. So that email ID, as probably you would see that most of the documents nowadays, when we draft, we also at the end of the document we also say that these are the notices served on the following address, or the email IDs would be considered as service of notice. So the banks also, some of the private banks also, I have seen, they have added those paragraphs in their agreements that the notice served on following address or the following email IDs would be considered as due service. Sanjay ji, can you just share some of your experiences on the service of the notice, or the contents of the notice, or the format of the notice? Sanjay ji, can you hear me? Okay, maybe he's fine.
Sanjay ji is self-muted, so maybe he can answer this later, perhaps.
Yeah, he can answer this later. So the second process is the section 13 subsection 3A, when the notice is received by the borrower and the borrower gives a representation. Borrower gives a representation against that notice, that would be considered as a conclusive evidence that the notice was served on the borrower, and the it will not be said that the notice was not served, because based on that notice the borrower submitted their objections also. See, like whatever you all say, it's very easy for a banker to sit in a room, make one letter, make second letter, make third letter, make fourth letter, and sell the property, and the matter can be considered as done away. So it was very cautious decision of Mardia Chemicals, and it was said that the process has to be complied with meticulously, and any error in the process would lead to stay. Any error would lead to reversal of the entire process. So again, coming back to the representation or the objection by the borrower, secured creditor shall consider such representation. The borrower will give a representation, the creditor will consider the representation. This earlier, see, this particular period was only 1 week earlier, with effect from 15th of January 2013. However, nowadays the reply has to be given in 15 days, and the reply has to be given by the bank, by the lender, within 15 days from the date of the representation by the borrower. The response of the secured creditor needs to be reasonable. Speaking response, reply to the representation is a mandatory requirement. So I think the largest litigation that we have seen is in this part of the law and the process, that the borrower keeps writing letters day after day, week after week, month after month, and finally the banks find it very difficult to reply to each and every letter, and then the borrower take the benefit of those some of the objections raised by the borrower and not replied by the bank, because most of the lawyers, they are advising their clients who are defaulters in some of the bank loans, that you should continuously write something or the other. You should submit one-time proposal, settlement proposal. You should submit the restructuring proposal. You should tell the banker for some defaults or for some difficulties in the statement, reconciliation of the statement. So the see, like, although no appeal can be filed by the borrower on the response of the secured creditor to DRT or the court of district judge under section 17A, because see, the whatever response is given by the borrower, by the lender. Now suppose the borrower says that I would like to pay in 10 installments, and the banker says that this your proposal is rejected for these following reasons, and that should be considered as the response, and the borrower will not have any option to go to DRT or any other court against that letter of the bank rejecting the proposal of the borrower. So this was like the reply to representation or objections. The In case we see this after the receipt of demand notice, if the borrower makes a representation or objection to the notice of SARFAESI, then authorized officials have to consider this. Also, this we have considered. Now, these are the various examples. Sanjay ji, are you there? Can you hear me?
Yes, sir. There was a sorry, there was a network connection problem. So
Okay, so
I'm audible.
we were discussing, we were discussing about the notice under section 13(2), and can you share some of the difficulties that you faced and some of the benefits that the borrowers have taken while the service of notice is not appropriate, and also how the notices are being served through email? See, I think you and your team has a lot of experience of this kind of notices. So you just share some of your experiences only restricted to the service of notice under section 13(2), and also uh, the other part is the objections raised by the borrower to the bank, and the borrower and the bank to revert back to the borrower on these two parts.
Yes, sir. So the notices, as per the amendment, this service of notice through electronic email were being notified as the valid mode of service. So serving through the email is now a valid proof, and the other way of servicing of the notice is actually the traditional one, which the borrower always objects in the court that I didn't get the notice copy. The person staying there is somebody else. I'm not staying there, so some tenant is there. So he generally avoids and show that he hasn't received the notice. So it is the main cause of delay in the further action, that in case he doesn't get the notice, then the court will also say that once the notice is not served, then the notice should be served again. So this is the main hurdle, that he avoids service of notice, that notice should not be served. Other thing is that when he gives some objection, then it is automatically being considered as the acknowledgement of the notice. Any objection, maybe a difference in rate of interest, a wrong mentioning of property detail, wrong omission of mentioning of any of the director in the notice, wrong address, wrong name. So he can take any plea in the court that there is a many errors in the notice. So this is the actually reasons, and these are the examples of the pleas which the borrower takes from the court, sir.
No, very good, Sanjay ji. This is a very important part that you stated. The name of all the directors are not mentioned. All the grunters are not mentioned. Address is not complete. I'm not staying at that property where CESPA is done. I'm not staying at that property where the courier or the registered mail has been sent. The amount
Yes.
mentioned in the notice is incorrect. The interest charged is incorrect. So these are the various kinds of uh, the shelters that actually is been taken by the borrowers. See, Sanjay, in the meantime, while I'm actually going ahead with a couple of slides, so in case you can also see whether some of your general managers can also share some of their experiences, practical experiences, and in case you
I think
can call them.
there. So this service of
Yes.
notice is a very primary requirement of the entire SARFAESI process, and there are a lot of questions. So I think I can take up these questions because they are very relevant to our discussion. So one
Right.
of the questions is that can the notice be sent through WhatsApp message? I think no. I think
No, no,
WhatsApp is
no.
not a notified thing, so maybe that will not work for us. Then we have a question that if a bank has already initiated procedure under a borrower in DRT, can you still go ahead with SARFAESI notices and SARFAESI action?
Yes, yes, yes. See, like the filing an application for recovery and also taking a SARFAESI action, that of course both can go concurrently. There is no difficulty in this.
Then I think we have already answered that whether we which emails we want to send the notice to will totally depend on the active emails of the borrower from which he has been making communication, and it is not necessary that that should be the CD domain, or that should be the some domain address of the corporate debtor or something like that. So of the borrower. So maybe we have already answered that. Then one interesting question is that if the borrower has replied and objected to the 13.2 notice, can after that objection the borrower say that I was not served the notice?
I think Advocate Sanjay Gupta has actually very clearly said that this becomes the conclusive evidence in case the borrower submits the objections to the notice under section 13.2. Then of course he
Then the
cannot go back
service,
and say,
yes.
that I have not got the service of the notice. Once the objections are served, that actually is considered to be something which is one hurdle over. And then the second hurdle comes is the reply to the objections.
So another question that is coming is in from Mr. Mahindra Arora, which says that whether notice is required to be sent to the guarantor of the borrower.
Your voice was breaking, so I couldn't hear the question.
I will repeat. So whether notice is required to be sent to the guarantor of the borrower.
The guarantor of the borrower under SARFAESI is only supposed to be sent a notice in case the property of the guarantor is also charged, because the SARFAESI Act is all about enforcement of security interest. So in case there is no property which belongs to the guarantor, so there is no requirement of sending a notice of, of course, the 13.2 notice should be given, because the 13.2 notice is payment. The guarantor can also make payment. 13.2 notice has to be given to the guarantor also, because this is regarding the final notice that you need to make the entire full and final payment to us within 60 days. And the notice also should go to guarantor, because the guarantor can also pay and the borrower can also pay. So this notice must also go to the guarantor.
Then there's a question that in case the notice is served to different parties as per the requirement of the Act, and different parties raise different objections or different letters to the bank. So the question is that, is there a requirement to answer to each and every of those letters? I think yes. Maybe there can be
Yes,
combined
it is
answer, but
required,
there should
because
be required.
no, first of all, only those people would be given a notice who are either the borrower or the guarantor. So there is no other party who is not connected with the debt. So either the borrower or the guarantor have a right to represent, and for each and every guarantor or for each and every borrower, the objections raised by them has to be reverted back and has to be seen, examined by the bank.
Then there's a question that can 13.2 be issued to the legal heirs of a deceased borrower?
Yes, in case a legal heir has been identified, then of course yes, and the SARFAESI notice has to go to either the borrower or to all those people who are inheriting the property, which is either mortgaged, to the bank, or all those people who are somehow entitled to the property of the borrower. So they all should be sent a notice.
Then another question is that can the notice only be sent to the guarantor and not to the borrower? I don't think so. I think you have to send it to both.
The notice has to be given to the borrower and guarantor both. It is not possible that the notice is only sent to the guarantor, because the language of the notice says that you have taken loan from us and you must pay us within 60 days. So that language itself shows that it has to go to the borrower and the guarantor also, because the guarantor can also pay.
Then there's a question from Mr. B.S. Murthy that if security interest is given to multiple bankers, I think there is a 60% clause that if it is given to multiple bankers, and 60% of those of the borrowed of the people who have money owed can initiate the SARFAESI process. I
Yes,
think
60% of the
I think
total
that was the
debt ratio in terms of the total amount outstanding. That would be the ratio which would be considered as deciding ratio. 60% of the total debt owners would be required to give a consent for SARFAESI action.
So I think you can proceed with the presentation. There are a lot of questions.
I can now.
There is
I
a
think
flood of questions.
yes, I think we'll be able to handle. So these are some of the examples. Yeah.
So okay, I can continue asking these questions until they're relevant.
Some of the questions actually will get answered in the process, Ankit.
Okay, so let me put this on hold, and maybe you can continue with your presentation.
Yes, yes. So these are some of the examples of the objections raised by the borrower. primarily the objective of the borrower is to find justice or to create hurdles or to some kind of get a benefit of delay. See, since the court is little slow, so any trick by any borrower can work. So the way which some of the objections which may relate to the limitation law is applicable. Notice not properly served, as Advocate Sanjay has already said. Bank has not appraised and the process and application for enhancement of credit facilities neither rejected nor accepted. The borrower's request for trust and retention account with tagging on revenue has not been processed by the bank, is pending with the bank. Statement of account is not provided by the bank. Borrower has submitted an offer for OTS, no response from the bank. Borrower submitted a proposal for restructuring and rehabilitation pending with the bank, and the bank has not reverted back. Property is not in the possession of the borrower, has been given to third party for operations. Property has been given on rent against a valid rent agreement. Most of the stock has been sent for job work with the third party job workers. So there are so much of the excuses which we actually find that the borrowers are giving to the bankers while they represent. So this is the one what see there are so much of litigation in this case, and in each and every litigation it has been held that the bank must react, bank must give a revert, bank must examine the objections and consider the objections and then provide a spoken order and why these are not being considered. So some of the judgments, and the very important judgment in 2018 which came from Supreme Court, it is in the case of ITC Limited versus Blue Coast Hotels Limited. In this case, it was held that sufficient time provided by secured creditors to borrower, and based on the facts of the case, it was considered fully complied with, and no relief was granted to borrower. Hence, failure to furnish a reply is not significant, while many other evidences are available for engaging with the borrower. So this is what exactly is the case. Maybe one small error. However, there were evidences that the borrower was being considered. All the representations were being considered. Meetings were happening. However, that official reply was missing. So the banks, in fact, this relief to the bank was also given by Supreme Court. Up to High Court, it was reverted back. But this is very serious issue that even if you are engaging with the borrower, even if you're meeting him every day, even if you're trying to find out a restructuring or one-time settlement or any kind of resolution for that stressed borrower, still in case you have not replied in writing to the objections given by them, to the proposals submitted by them, it is actually very difficult to continue the process of SARFAESI. It is now the Supreme Court has just given one relief that if one reply failure to furnish one reply is not significant, there are many evidences that the borrower are being considered. Now coming back to the step 3, so we have already seen the step 1, step 2, step 3, and then step 1 is the 13(2) notice, step 2 is the representation by the borrower and reply by the bank, and step 3 is now section 13(4). 13(4) is like everyone knows, whosoever is engaged in SARFAESI profession, SARFAESI law. And the clause A of the 13(4) says these are the measures which can be taken by secured creditor for enforcement of security interest or for the recovery of the secured debt. The first option is to take possession of the secured asset, including the right to transfer by way of lease, assignment, or sale. Second option, take over the management of the business of the borrower, including the right to transfer by way of lease, assignment, or sale for realizing the secured assets. Only if substantial part of the business is held as security interest, then only you can take over the business of the corporate debtor. Like in case only one of the building is mortgaged and the entire business of the organization cannot be taken over by the bank. Appoint any person as a manager for managing the secured asset, the possession of which has been taken over by the secured creditor. Require any time by notice in writing any person who has acquired any of the secured assets from the borrower and from whom any money is due or may become due to the borrower to pay the secured creditor. So much of the money as is sufficient to pay the secured debt. Now let us understand what is the meaning of clause A. Clause A is very clear, taking possession, symbolic or physical. That will come later. Second is that we can take over the management of the company in case the company is running. We can take over the management and appoint a manager. And the third is that we can even take over, we can write all the debtors that we recover. Because in case the book debt is hypothecated, in case the book debt is hypothecated to the bank can write and give a notice in writing to all the receivables, to all the sundry debtors, that all the money, whatever they owe to the company, to the borrower, must be paid to the banker, and the banker would be able to discharge that amount by issue of valid receipts. So this power has rarely been used. Secondly, the taking over of the management of the business of the company is also being rarely used, because the banks couldn't find a proper process of the appointment of manager and finally monitoring of the manager. So this is the 13(4) options, right from the possession of the asset, possession of the management of the control of the management business, appointment of manager, taking control of the receivables. Now step 4, and in case we see the under step 4A, the step 13(4)A is about taking possession, and in this regard, if the possession is not easily available, if it is not voluntarily being offered by the borrower, then the bank can make an application to CMM DM having jurisdiction over the location of the asset or other document in writing. Take possession of such assets and documents relating thereto, forward such assets and documents to the secured creditors. That's what is the application to CMM, that the CMM or DM should take the possession of the assets and hand it over to the secured creditors. So in the process of making application to CMM, now the section 14 was inserted later on, and an affidavit which has to be given by the authorized officer, and that affidavit is also kind of a confirmation and a statement on oath by the authorized officer that this and this process has been completed, and this and this has actually been done, and along with the evidences that application has to be complete. In case the application is not complete, the affidavit is not as per the prescribed format, if the documents as prescribed in section 14 is not attached, then this may cause delay. And this is actually this is the biggest time wise, this has been the biggest delay in the SARFAESI matters. The application is pending with this DM or CMM, and the action is not happening, order is not coming, DM is not supporting, and in most of the cases you would find the reasons is that the application is not to the satisfaction of DM, it is not as per the format, it is not as per law, some of the documents are missing. The amendment which took place on 1st of September 2016, now it has been written in the act that the CMM the DM should pass the order within 30 days of the date of application, and in case it is not able to be, it is not possible for him to do it in 30 days, then he can do it in 60 days and after recording reasons for the delay. CMM also can delegate these powers to any subordinate officers to him for taking possession and forwarding the same to the, and that is the reason that we have seen now the appointment of Naib Tahsildar, etc. Sanjay ji, I think you should share some of the experiences of DM CMM order. I can, let me finish whatever I have, then I think I need practical experiences regarding DM orders. DM may take all steps or may use force. DM can use force also. DM order can be questioned, cannot be questioned. Once the order is given, it cannot be questioned. Now the lenders can take possession without the DM orders, and that is not necessary. As I said, that this is such a law that the banker can sit in his room and can do everything and can sell the asset, and it is not required in case there is no resistance. The action taken by the banks for taking possession is fully protected under section 13(2). Now the CMM has also been equated with the chief judicial magistrate, so that also can now handle the orders. that also can issue the orders and take the assets. This has been held by Supreme Court in the case of the authorized officer Indian Bank versus D. Visalakshi. So this is 2019 judgment of Supreme Court, and this is also very important that in case DM is not giving order, then we should try CJM, and CJM can give these orders. That's also very important. There is a procedure completely mentioned in the rules for taking possession. So what is the procedure for taking possession, and if there is any skip or any miss in the procedure, then also either the DM would not give the order, or the application would be filed to DRT for not complying with the rules. So this is actually provided in Rule 4, possession of movable secured assets. The first part deals with the possession of movable secured assets. Sanjay ji, I think here you can now give me or give the audience some kind of experiences that you have, where you can actually talk about the various difficulties for making application to DM, or rather follow up with the DM, or the attitude of the DM offices, whatever the practical experiences are. Sanjay ji.
Yes, sir. So first difficulty, this topic is about the difficulties being faced on the SARFAESI Act. So first difficulty would be the applying to the DM, CMM and getting the orders in many of the states in India, as we are working already in 22 states. And in many states, Delhi, Ghaziabad, Chandigarh, Punjab, Meerut, Saharanpur, we are getting the orders in 1 month's time. And there is no much delay being seen in these states. So we have seen some delay in Maharashtra, in Kolkata, due to various reasons. Some of the districts of UP, we have seen the delay. The delay is basically because of the different practices being adopted by CMM, DM in their offices for filing the application, format of the application, their annexures and all, and affidavit. So first difficulty is that we have to keep the file according to the requirement of the DM and CMM. So then there is a different time being taken in obtaining the orders because of some local issues over occupation of the magistrate. But there is a amendment coming on 1st of September. You already mentioned that it has notified by the government that DMs have to issue the orders within 30 days or maximum within the 60 days. By mentioning the reason of delay, why he has given the orders, delayed orders. And many of the district in India, maybe 40-50%, they are still taking more than 6 to 9 months of time. And maybe the borrower influence some of the DM office, their official staff. This is maybe the reason. CMDM find the case a high value case or a high profile case, maybe education institution, maybe factory where there is a threat of going many of the labor to protest such cases, some local festivals, local issues, local election time, labor court. So these are the various issues that come across while we go to the DM and for apply for the their orders. So these are the issues are being faced, but we handle them well, sir, as we have experience of 25,000 cases, and we are working in 22 states now. So we are very well averse with the as bank. We are working as the outsourcing agency for the banks. So we do a full experience with the full experience and full expertise. We do as per the local DM procedure which is being followed in their offices. So we are pretty much faster in getting these orders in these districts, sir.
Good, Sanjay ji. I think let us try to understand the rules, because my part. Yes, Ankit.
So one question is that the affidavit to DM is required to be filed by authorized person, or can it also be done by the manager appointed to look after the secured property? So I think the answer is authorized person.
Authorized officer. The manager has got a different role.
Yeah,
manager has got a different role, and the authorized officer has got a different role, and it has to be signed by the authorized officer. So now, see, when we see this Rule 4 of the enforcement of securities enforcement rules, and we saw the kind of meticulous details which is given there. So what is the procedure for taking movable secured, possession of movable secured assets? Like where we say possession of movable secured assets means like any movable assets, movable capital asset, movable stocks. The procedure for the possession is the authorized officer shall take possession along with two witnesses. Panchnama would be drawn and signed by witnesses. Format of the Panchnama is also given in Appendix 1 to the rules. Inventory of the movable asset has to be made as per Appendix 2. A copy of the inventory has to be delivered to the borrower. Notice to the borrower enclosing Panchnama as per Appendix 1 and inventory as per Appendix 2 that has to be given to the borrower. So once we take the possession, we create all the documents like Panchnama in Appendix 1 and the inventory in Appendix 2. Then we have to give a notice to the borrower where the Panchnama and the inventory would be attached. And that notice also has to be served the same way, because the serving of the notice, as we have already discussed, for all the notices, whatever we serve under this SARFAESI law, that has to be served in the same manner as we have already done, as we have already seen and discussed. So each and every notice has to be done in the same manner. The notice to be served through electronic mode, that is email, and also as per the notice serving procedure, also as per notice serving procedure which has already been discussed. Then is the custody and care of the property by the authorized officer. So once we have taken the custody of this secured asset, I see we are still at movable asset, and we will go to the immovable asset, because presently we are only attending to movable asset. The custody would be owned by the authorized officer. Audio connection has been lost. Attempting to reconnect. Am I audible?
Yes, sir. Now it is
I'm saying
audible. Earlier,
now it is audible. It was missing for maybe 2 minutes. The last.
Okay, so I think one very important part that I said in this case is that whenever we take possession of movable secured assets, we prepare Panchanama in Appendix 1, we prepare inventory as per Appendix 2, and the notice would be given to the borrower where the Panchanama and the inventory would be attached. And this notice also would be served through electronic mails and also as per the notice serving procedure. Then I said that each and every notice which is to be served to borrower has to be done in the same procedure as we discussed under section 13.2. So each notice is very important, and for each notice there can be a default, there can be an error by the bank, and that has to be safeguarded. So today's topic is how we can safeguard the delay. So in case we try to do all the documentation as correctly as mentioned in the rules, then probably in case somebody would try to go to the court, we can present all the documents in no time to court, and then the stay would not be granted. However, in case we take 2 or 3 hearings in collating our documents and presenting before the court, by that time 1 year would be lost or 6 months would be lost. So each and every document has to be collated well in the file. So whenever there is a requirement, whenever there is an application filed by the borrower, on the first hearing itself, we should present all the documents so that the borrower is not able to pinpoint any deficiency in the process. So the authorized officer will take care of the assets as an owner would have taken, authorized officer to preserve and protect the assets, authorized officer to keep the insurance intact. This is all provided in the rules. If the property is subject to speedy or natural decay, or the expenses on the care of the property would exceed the value of the property, then authorized officer may sell the property. So this process it's like now these are the movable assets, and like what we attended so far is movable and tangible assets. Now, in case we come to something which is the secured asset other than the physical asset, like means intangible asset. So in case a debt not secured by bill of exchange, hundi, etc., collection to be made by the authorized officer, and all efforts to be made that payment is not being given to the borrower. So this is also mentioned and provided in the rules that in case of receivables, the receivables should be collected by the authorized officer, and all the efforts should be made that the payment is not made to the borrower and the payment is made by the debtors to the authorized officer and not to the borrower. So in case of shares, to get the shares transferred to the borrower's name and to make sure that the corporate is also informed not to transfer the shares to any other person other than the authorized officer. So in case it is a case of pledge of shares or hypothecation of shares, then in that case the shares has to be transferred to the borrower to the name of the bank. For any other immovable property, take physical possession and reach out to all those who are having possession of the property and take possession. For other movable property, authorized officer will take custody and control over the documents of the property. So practical difficulties, as Advocate Sanjay has already mentioned, practical difficulties while we are taking the DM order, like for the sake of convenience, I would only say DM order. While I am saying the DM order, it would mean CMM order, CJM order, or DM order, anything. So the practical difficulty is that there is no standard document or process in the offices of DM across the country. Different time taken in the obtaining the order because of local issues, over occupation of the magistrate. After the amendment date September 16, the time has reduced substantially. Sanjay Gupta, Advocate Sanjay Gupta has already taken care of this part, and he's now satisfied. However, it's 40% districts in India is still taking more than 6 to 9 months. Borrower's influence over DM office also work. DM also finds some cases which will be prone to law and order unrest. Some local festivals, as Advocate Sanjay also said, some industrial court, some labor court, some industrial dispute, some the payment of wages dispute. All these things can actually work as a hurdle in taking the DM order. The Supreme Court has given a very, very important order in 2018 in the case of authorized officer State Bank of Travancore and others versus Matthew KC. It is held by the Supreme Court that it is a solemn duty of the court to apply the correct law without waiting for an objection to be raised by the party, especially when the law stands well settled. The financial matters. This particular order is primarily considering various injunctions granted by DRT or DRAT, and the court said in financial matters, grant of ex parte interim orders could have a deleterious effect, and the aggrieved had the remedy to move for vacating the interim order. Loan by the financial institutions are granted from public money generated at the taxpayer's expense. Such loan did not become the property of the person taking the loans, but retains its character of public money given in a fiduciary capacity as an entrustment by the public. So this particular order of the Supreme Court was a kind of stricture on various courts who were actually giving ex parte interim orders. So this, of course, not very important, but then the legal hurdles that we actually have seen while taking the DMM order, CM order, DM order, and there are various pleas that has been taken before the DM, and that says like tenancy of the third party. We will come back to the tenancy issue. Property not separable from the other properties, and in that manner, the banks have to just find out identify the properties, and rather at the time of giving loan itself, the bank should be able to handle it appropriately. The property not identified, the family partition suit, title suits of the properties also. These are the legal courses that are being taken by the borrowers over a period of last 17 years. Normally they ask the family members to file a suit on the ownership of the property. They would try to make the property as an HUF property. Family members challenging the authority of the borrower to mortgage the property being subject matter of a will or a dispute or a HUF. Conveyance deed is defective or duplicate. multiple mortgage found, service of notice challenge before DM and the period of 60 days is not provided, total claims of the lenders challenged and some conflicting documents placed, limitation period challenged, that is time barred, it is normally argued, property details of the assets are not provided or not correct, NPA classification done by the banks is incorrect, objections and representations of the borrower not properly attended or not responded, borrower has made some payments after the notice, OTS proposal is not considered, various legal reasons that they normally take. So this is the whenever we try to take this legal issues, and the litigation with the CMM DM has actually reached kind of a level now for the after the amendment in September 2016, it is kind of considered as somewhat settled. The legal issues and litigations are now settling down. DM cannot entertain disputes relating to the jurisdiction of the secured asset. The judgment has been provided guidelines for the DM for issue of powers by them, and later those guidelines became part of the act in 2012. This particular order, which is KR Chandrasekharan versus Union of India, in this particular order gave a lot of directions, and all those directions were captured in that DM, the affidavit which are supposed to be submitted. Now the rights of the lessee and the rights of the tenant while SARFAESI Act is invoked, this also the Harshad Govardhan Sondagar and versus International Asset Reconstruction Company Limited. The primary so far, the tenant is being protected. Tenant is being protected by the SARFAESI. Tenant is being protected because see, it has been held at various courts that how the tenant can be evicted if the tenancy is genuine. If the tenant is bona fide, how can the tenant be evicted? However, in certain cases where the tenancy was verbal, see, like I can even explain to you why the courts have taken this kind of stand. In India, there are various areas where the properties are occupied by tenants, and small portions of the property are occupied by various tenants, and they are paying rent starting from 5 rupees a month to 500 rupees a month, and they are occupying those properties for the last so many years, and also they are like trying to pass on to the others on goodwill basis. Now, in case the SARFAESI Act is considered to be overriding the tenant's rights, then all those properties which has got huge value, and those values can be unlocked by the owners by just taking loan and defaulting, and this application of the SARFAESI Act can be made as a help to those landlords where the properties are occupied by multiple tenants. In Delhi also we have Old Delhi. In Mumbai also we have many buildings where the multiple tenants are living. So the courts are very cautious while they pass an order, and from case to case basis they are not really comfortable in evicting a tenant, and unless they see that the tenant is a standalone person, the tenancy rights were considered to be a backdoor entry by the tenant, or it was also not completely documented, and it was also the relationship between the tenant and the borrower is also seen. So based on these various facts, the only safeguard the banks can take, the banks should not wait. Whenever the default is there, after a few attempts of settlement or after a few attempts, the SARFAESI action should be taken, and the borrower should not get an opportunity to get this occupied by a tenant. The borrower should not get an opportunity to hand over the possession to somebody else. So that is the safeguard, so that the borrower should not go and take the kind of hand over the possession to somebody else. The right of the lessee is again like some kind of various orders that I can read. To prove valid tenancy, produce proof of execution of a registered instrument. if unregistered oral agreement, then DM to come to a conclusion that the tenant not entitled to possession from the date of the instrument or the date of the delivery of the possession. Non-registration of a lease agreement does not render such tenancy nugatory, because this is also one very important part that I was discussing. And most of these tenancies that I am saying in the Old Delhi or in Old Bombay, those tenancies also would not have registered tenancy agreement or lease agreement. So it is not something which is a tenancy negate. Negation is not possible because of the non-registration. Attention must be paid to the relationship between the two parties in the lease agreement and their rights and liabilities. The fact that there is a regular payment and acceptance of rent is important. No undue advantage can be taken on the basis that the lease deed is unregistered. Powers is given to the DRT now. See, this is a very, very important part that I want to discuss. See, earlier the rent disputes were not being handled by the DRT, and now from 4th of November 2016, the powers has been given to the DRT to handle disputes of tenancy of the secured assets. And it has also been provided that in such cases, the lessee or the tenant can move to DRT under Rule 13A. And the application form has also been provided. Appendix 10 has been provided, where the application can be made by a lessee or a tenant to DRT. So the dispute regarding the symbolic possession and physical possession, it has already been held that the asset can be sold by taking symbolic possession or physical possession, and after the sale of the asset, physical possession can be taken. Even after the sale of the asset, the lender can invoke SARFAESI provisions for taking physical possession. Dispute regarding this is already handled well. So there is no doubt about this now, that the symbolic possession or physical possession, it all depends upon the practical part of it. In case the property can be taken physically, and it is possible, then of course it should be taken. However, the property can be even sold on the basis of the symbolic possession. Property identification is not correct. I mean, these are our experiences of taking physical possession. Police force is not cooperating for breaking open the doors. Police force is less as compared to the resistance from the borrower's family and friends. Borrower taking a stay from the court on various grounds. Worker resistance to physical possession. Borrower pending disputes. So these are various experiences of taking physical possession. I actually will come the valuation. Of course, everyone understands that we have to evaluate, and after the evaluation, we need to do this fixation of reserve price. Now it comes to the major part of the sale that I want to attend. I want to deliberate today is the sale part. The purchase of the property by secured creditor. I mean, that's something which we already discussed in the series 1. Now it is the sale of the secured asset by the secured creditor. I mean, this is handled by section 13(7). And first, the steps are first, all cost, charges, expenses of the sale. This is the any transfer of secured assets with possession by secured creditor shall vest in the transferee all rights in or in relation to the secured assets as if the sale has been done by the owner of this asset. Distribution of the proceeds of the sale of assets would be under section 13(7). First of all, the cost, charges, and expenses on the sale, preservation of the asset would go. The amount would be paid to the secured creditors. Then the balance would be paid to the person entitled to that money in accordance with his rights and interests. So this is the distribution process. Sale can be made if the amount, sale cannot be made if the amount due is tendered. Section 13(8) says that if the borrower is tendering the amount before the date of publication of the notice for public auction or inviting quotations, private treaty, in case before any of these three things, in case the money is tendered, then the sale cannot take place. 66% of the secured creditor shall agree for any action under section 13(4). I think it is, yeah, 66%. Secured creditor can file an application to DRT for recovery of the balance amount, like whatever is the balance amount after the recovery from the secured assets. That of course can be filed to DRT. Now we move on to the sale of the assets. So this is a different part, and there are so many amendments also in this part. I would like to go through this part as a very carefully, and maybe that we again exceed some time as against the stipulated, as against the planned 2 hours, and because the sale of movable secured assets and the sale of immovable secured assets, that needs to be discussed carefully. So there are methods which are provided in the rules for the sale of movable assets. First, asset can be sold in one or more lots, as we do in liquidation also. Obtaining quotations from the interested parties means no public notice is required. So in movable assets, we can take quotations from the interested parties as one of the method. The second method can be, we can invite tenders from the public. When we invite tender from the public, in this case, public notice would be required. Holding public auction physically or holding public auction through e-auction, or sale by way of a private treaty. So these are the 5 methods of sale. 1, by obtaining quotations, tenders, public auction, e-auction, private treaty. However, it is very, very important that notice to the borrower before the sale. Again, we come back to the notice to the borrower. 30 days notice to the borrower before the sale of movable assets. Whenever we try to sell an asset through any of the above 5 methods, 30 days notice to the borrower has to be given. Service of the notice as per the service rules, as we have read under section 13(2), the notice would be done, notice would be serviced on the same method. However, in case the first sale fails by any of the above methods, then notice for the second period, for the second time sale or auction, that would be that can be 15 days. So whenever I say as with the notice, now the notice is not simply notice. If we go back, it is a notice by various methods. It is a notice by way of the public notice in the newspaper, and there is an amendment now, and whenever there is a public notice which is in two leading newspaper, there is an amendment on 17th of October 2018, the Security Interest Enforcement Amendment Rules, and now it has been provided, one, that there is a form which has been prescribed. There is a form which has been prescribed, which is named as Appendix 2A for giving public notice of the sale. And what information is required to be given in that public notice is also provided in the rules. So this has to be meticulously followed. Service of notice for sale, again, service of notice, of fixing of the notice, publishing of the notice, all three in the same manner as we have read in Rule 3. And that is the entire process of serving of notice is to be completed. In case we are doing 10 sale processes, then 10 times the service of the notice has to be done. In case we are doing 10 sale processes and we are not getting success, then each time we have to do this service of notice to the borrower. This is the little complicated part of the processes, because nowadays we are not finding customer. So the banks are doing it collectively. The banks are doing collective notices in the newspapers, collective for various properties. And also the all the public notices, whatever we are giving, the amendment dated 17th of October 2018 says that the authorized officer shall upload the detailed terms and conditions of the sale of the movable secured assets on the website of the bank, on the website of the secured creditor, means NBFC, ARC, or the bank or the financial institution. So even the contents of the public notice for sale is also given. It should mention the detail of the secured creditor, that is the bank, details of the borrower, description of the movable assets with numbers or identification marks, reserve price fixed by the secured creditor, time of payment, manner of payment, time of public auction, physical or e-auction, start time of the auction, end time of the auction, time by when the sale would be completed by any mode, place of e-auction or link for e-auction, earnest money deposit, amount and mode of deposit, other information about nature and the value of the movable asset. So all this has to be done. It is not my own creation, it is provided in the rules. So these rules are to be followed meticulously. Then only the error-less process would be conducted. So the sale is process, this is that we discussed about the sale of movable assets. And again, in case you see the value of the asset is small, then maybe the expenditure would be too much for public notifications, public notice, and also to the notice of uh, to the borrower. So there are two notices that we are talking about. One is the notice to the borrower, and the other is the public notice, and the third is the uploading detailed terms and conditions on the website of the secured creditor. Sale by any other method other than the public auction or public tender. In any other such sale methods, the terms to be settled between the secured creditor and the proposed purchaser, the terms to be settled between the secured creditor and the proposed purchaser, the owner of the asset or the borrower is not required to be consulted or to be party to it. This was amended with effect from 3rd of November 2016, and it has been clarified now. Earlier, the words between the parties in writing is replaced between the secured creditor and the proposed purchaser. So the parties, it was confused along that the owner of the asset also needs to give consent. However, now it is very clear that for even any private treaty, the consent of the borrower is not required. This is the effect from 3rd of November 2016. Finally, the issue of sale certificate, it is provided in Rule 7. This is regarding the movable assets. Sale price of each lot shall be paid as per the terms of the public notice or as per the settled terms. In case default in payment, movable asset will be sold again. After the repayment is made, AO shall issue a sale certificate in Appendix 3. So it is actually made in such a manner that the formats and every kind of document is already provided, the contents are already provided. The sale certificate will be will transfer the title to the buyer, and the sale would become absolute. This procedure is applicable to all the movable property, debt or receivables, sundry debtors, or beneficial interest in the property. So we might even finish here the movable assets. From movable assets, we move on to the sale of immovable secured asset, which is provided in Rule 8. And there also the amendments has taken place. So I would ask all the participants to be careful about the various amendments. And I have seen practically that most of the banks, they are still continuing with the earlier processes, and they are still continuously taking some kind of consent from the borrower for even selling the property. It is not provided that private treaty can it is not provided anywhere that the property cannot be sold in private treaty unless a public auction fails. There is nothing like this in the law. There is nothing like this in the rules. The authorized officer can take a decision whether to sell the property in first manner or the fifth manner or in any of the 5 methods. So in this, the first step in the sale of immovable property is the step 1, service of possession notice. As I said earlier, when we were taking the possession of the movable assets, and we had seen that we actually made Appendix 1 and Appendix 2, and a notice was given to the borrower. Now, in the case of immovable assets, the AO will take possession, symbolic or physical, by delivering a possession notice as per Appendix 4. Affixing the possession notice, symbolic or possession, on the outer door or at such conspicuous place of the property. Now let us see how many notices are now being provided in the law. One notice that we have seen is the 13(2) notice. Then we have seen the possession notice that we actually have to give to them. Then we have seen the sale notice. So, and multiple sales, multiple sale notice, multiple times that we have taken possession of different assets, then we have to give multiple possession notices also. So there are various notices that has to be given, and the basic concept of giving all these notices is, and this was held by Mardia Chemical, that this is a very big power, and the bankers the lenders must follow the process. So in case the process is not followed, that would be considered as the process not conducted properly, or it can be reversed. There are various judgments where the entire process has been reversed. So this is a possession notice which is being served by a fixing. Possession notice shall be published not later than 7 days from the date of taking possession, again in the newspaper, one in English, one in vernacular, again to be served to the through the electronic mode in an email. See, then the custody, step 2, once we taken the physical possession, the custody and control, the custody, preservation and protection of the secured assets. In the case of physical possession, as we have seen in the case of movable assets, the AO shall keep the asset in his custody or any person appointed by him. AO to take care of the property as an owner would have taken the care to take all steps to preserve and protect, to secure the asset for the insurance purposes. Here also the Supreme Court has held in the case of Hinton Forge Private Limited and others versus the state of Uttar Pradesh and others. Borrower has the right to approach DRT under section 17(1) seeking remedies. The amendment dated 17th of October 2018 makes it indifferent, as Appendix 4A has been inserted, which clarifies that the property can be sold even after symbolic possession. So this was a Supreme Court judgment in the case of Hinton Forge Private Limited, where it has been held that now, since the rules have been amended on 17th October 2018, Appendix 4A specifically provides the word symbolic or physical that actually means that the assets can be sold even after taking symbolic possession. Step 3. So we have taken the first step, second step, and third step is to get the valuation of the property and to fix a reserve price. Step 4. Decide out the following method of sales. For the immovable property, we can even sell the immovable property by obtaining quotations from the interested parties or parties generally dealing with the similar assets. We can also seek tenders from public. We can have public auctions, e-auctions, or private treaty. From 3rd of November 2016, no consent of the borrower or the owner of the asset is required for private treaty. Earlier, it was held by some of the courts that it is required, but now it is not required. The banks are free to sell the properties without taking consent of the borrower. Step 5. AO to serve 30 days notice or 15 days notice to the borrower for sale of immovable property, 30 days for the first sale process and 15 days for all the subsequent sale processes. How the notice would be served? AO to serve notice to the borrower and the owner of the property, borrower and the owner of the property, to both. It has to be served that the sale is proposed through obtaining quotations or private treaty. In case sale is proposed through public auction, e-auction, or inviting tenders, then the newspaper advertisement should be given. Notice to be affixed on the property. Notice on the website of the secured creditor, that is banks, ARC, and NBFC. This is amended with effect from 17th October 2018. Earlier, it was not required that the website of the secured creditor also should have the information of sale. No sale shall take place before the expiry of 30 days from the date of service of the notice. If sale at the first instance fails, then for the second or subsequent sale, 15 days notice is enough. So how many notices? Like, again, notice. Once the public notice again, after the website, and the affixing also. All the three things has to be done. Step 6. Contents of the 30 days notice or 15 days notice to the borrower for sale. Description of the immovable property to be sold, total amount of debt for which the property is secured or total amount to be recovered, reserve price, time of public or e-auction or last date for submission of tenders, place of public auction or e-auction, details of the place of submission of tenders, earnest money deposit, any other details. The secured creditor shall cause a public notice in the form given in Appendix 4A, amended as per the as per the Amendment Act dated 17th of October 2018. Now comes the confirmation of sales, issue of sale certificate, delivery of possession of immovable asset. So as I said, that no immovable property can be sold before the expiry of 30 days from the publication of the sale notice. If it is in the case of subsequent or second sale, the 15 days notice is enough. Confirmation of sale can only be given to the highest offer, whosoever has been given by way of a bid, tender, quotation, or even otherwise in writing. No confirmation of sale price if the amount offered is less than the reserve price. No confirmation of the sale price if the amount offered is less than reserve price. Sale can be confirmed at a price which is less than reserve price. 25% of the purchase price to be deposited within the same day or next day, balance within 15 days, and the 15-day period can be extended up to 3 months. This was also an amendment done on 4th of November 2016, that the period can be extended up to 3 months in writing between the purchaser and the secured creditor. In case there is a default in the payment, then the amount would be forfeited, and that amount will belong to the secured creditor. That was also clarified on 3rd of November 2016. On confirmation of the sale, the AO shall issue sale certificate. I think we have to discuss, Sanjay ji, the practical part of it, because the sale process that we have seen now, how many notices that we are supposed to give in public, how many, all this has to be uploaded on the website of the secured creditor. The borrower should be given notice by way of affixing, means CESBA, public notice, website, and notices through email and the other notices. So in each sale process, all these notices are supposed to be given. The rules are very, very strict. No process can be left from complying. So till now, what experiences you would share, Sanjay ji, like in the sale process, what kind of hurdles or what kind of practical difficulties are being faced?
Yes, sir. So the main
also,
difficulty.
Ankit, we can take some of the questions also, and later on we'll have after these question sessions or Sanjay's session, I will take only 5-7 minutes, and we'll conclude that. Yes, Sanjay ji.
Sir, if we start with the two main notices which we are facing with difficulty since the last many years, so which was eventually taken care through the amendment. That first one is that the possession notice is to be affixed, then it is must that possession notice should be served by way of speed post or and email. So this is one of the major hurdle by way of which many of the borrowers have taken stay, that even if the possession was taken by way of affixation and it was also displayed in the newspapers, but it was supposed to be served through speed post also. This was the one main mistake, you can say, and one step which most of the banks and most of the agencies were missing. So this was the major cause of stay for the borrower. Second, the sale notice, which is to be published in the newspapers, and it is to be served through speed post to the borrower. So borrower and the mortgager, these are the main two issues, main
and
processes.
It was also supposed to be fixed, also to be affixed.
Yes, sir. Also to be affixed.
Also to be affixed, and also to be uploaded on the website.
And sent through the speed post also. This is the 30-day sale notice is required to be sent through speed post. So these is the process which is being skipped. Bank thinks that once it is published in the paper, so may not be required to send it through speed post. So these through two notices, possession notice, sale notice is meticulously, it is must to be sent through speed post to avoid any complicacy or stay in the further process of sale. So these are the main two issues in this process. Otherwise, SARFAESI has been effective through amendments and all, and we are getting better results now. If time permits, we can add the comments of our general manager. If you think it is a time, I think it is already 6 o'clock. So
no, we can borrow some more 15-20 minutes. We can borrow, because the subject is the personally we need to understand their experiences, like basically the experience at the ground level, which they are handling, and also Ankit will read some of the questions.
Ankit, you can add
So
Mr.
I am
Sanjeev Mittal.
Sorry. So I
If
am
you can,
unmuting Mr. Ramesh Giri ji.
yeah. Yes, Mr.
Good
Ramesh
evening,
Ramesh,
Giri,
you
you
good
are
are.
evening,
unmuted.
everybody. Good evening, everybody. Mr. Goel and Sanjay sir has taken all the points in a right way. He has covered all the points. I would just add one point, that is caveat. After 13.4, every action we should file a caveat just to avoid the ex parte order from any court. Because it has been seen then when we are going after 13.4 and going to take a physical possession or for selling the assets, we found that borrowers get stay. This is the reason why means we were not informed. So just be informed, we should file a caveat after every action after 13.4 or any action after 13.4. So that is my advice.
That's very good, Ramesh ji. This you have actually.
Yes, surely,
This is a
surely.
very good tip, very important tip that you have given for safeguarding the delay. For safeguarding the delay. Any other the experience that you would like to add? Normally, which mistake is very common? Which few mistakes are very common that you can let us know? Maybe mistake from the banker side or from any way where the borrowers are taking advantages.
Sir, I would add one more point. It's not a mistake. It's just a fear. What I found between the authorized officer, that we should not take possession without the DM order. Even we know the property is vacant and we can go directly and take the possession, as this SARFAESI Act rightly make them incompetent to take the possession without the intervention of the court. Even then, the bankers are just ignoring or avoiding this thing, and they usually prefer to go for physical possession with the DM order only. So that also makes a delay, because we know the administration takes time. Means filing a DM application, getting an order, it's a big hurdle. Then executing the order is also a hurdle. Means making a coordination between the bank, executive magistrate, and the police authorities. It takes time. So if the
I,
property is vacant, yeah.
I think you're very right. Let us understand, like in case we don't take the permission from DM, then what are the evidences created for taking physical possession? Whenever we take the physical possession, we prepare a document, and that document is served to the borrower. And also that what are the other formalities that we are supposed to do when we take physical possession without DM order, and how do we create all the evidences that we have taken the physical possession? Of course,
Yes.
one, we have already seen that the notice is given to the borrower and the owner of the property. And what else we do after taking the possession?
So for taking
Yes.
possession without any DM order, we need to do some precautions like pre-intimation to the local PS before taking the possession. We should inform to the local PS that we are going
Local
to
police
take the
station.
physical possession.
Local police.
Local police.
Local police
Yes.
station, yes, because we are
Hmm.
entering in their jurisdiction, so it's our duty to inform them first, then only go. If any hurdles comes, even we know that the property is vacant, nobody will come, no law and order situation will arise. If something comes, then definitely we can call to the local police or we can come back from there. Otherwise, they can ask, how can you enter without informing us? And even after taking the physical possession, we should inform them that we have taken a peaceful possession of this property and just make it documented. And one more point I would add for the symbolic position also, whenever we go for the position of the property, we can advise to the authorized officer just to make a panchanama for every position. That makes a documentation for the position that in the presence of these witnesses we took the position.
But that's also a requirement, because whenever we go and take physical possession of any property, you will also have some of the movable items there. So for
Yes,
every
sir.
movable item, you need to prepare a panchanama in Appendix 1 and Appendix 2 format,
Yeah.
and that has to be serviced. That has to be also serviced to the borrower. So that is a very important part. I think you have actually touched two very important part. One is the caveat, and the other is the information to the police before and after taking the possession. Also creating a lot of evidences that we have taken the possession. I think the most of the bankers must be hearing this. So taking a physical for taking physical possession, DM order is not mandatory. This is the law, and we can definitely sell the asset after taking the possession even without taking the DM order, and that should be clarified to most of the teams working in the banks. Ramesh ji,
Right.
you are doing a wonderful job. I think you can add further few more tips, or we can even call Mr. Sanjeev Mittal, Advocate Sanjeev Mittal, who work out of Aligarh, and
Yes, sir.
he can also be added and can share, because this is a wonderful addition that Mr. Ramesh Giri has made.
And or Mr. Aditya Jain can be tried. Ankit.
Aditya Jain can also be made. He can also be invited.
And sir, other proofs that videography, photography, that also are must in any way for creating the
Yes,
proof of
that
taking
also
the.
you are adding, because the videography of
Yes.
taking possession or photography while taking the possession, and even the date also, that we normally authenticate
Yeah.
the date by showing a newspaper of that date, so that we also can say that this is the date when we took the possession. So this is not something which is done in back date. So that is very,
Yes.
very
Yes.
clear evidences of taking possessions, videos and photographs, all can be presented. So DM order is not required in certain cases where the resistance is not there. So wherever there is a resistance from the borrower or from the workman or from any other party, then only the DM order is required. Otherwise, the DM order is not required. So Sanjay ji, you can add Mr. Aditya Jain or Mr. Sanjeev Mittal, whosoever is available, for sharing some more
Yes.
practical tips.
Yes. I'm trying.
So
I'm adding.
he's coming here. He's coming to join again.
I
Mr. Mittal is
am.
coming.
I have just added Aditya, and
Okay.
I have also unmuted Aditya.
Yes, Aditya.
Aditya, you're unmuted.
So Aditya, can you hear me?
Aditya has gone offline now, and Sanjeev ji is also offline, unfortunately.
Okay, he's
Oh,
also offline.
okay.
Because I think
Okay,
there are
okay.
network issues for them.
Yeah,
Maybe
network
there.
issues.
Yes. Yes.
So there
So,
are a lot of questions, and
yeah.
I think I will try and pick out the ones that are relevant. Um, um, so I think I will just filter them out, because I think there are some exceptions with respect to legal heirs. I think we've already answered that, and beyond, so I don't think there's anything else we can do about it. Um,
Legal heirs, I would add, sir, is a major issue where the borrower or the mortgager has expired. So it is not that he should be served a notice. It is a mandatory. He must be served with the notices. Even the,
Hmm.
only after then we can pursue for the enforcement of security interest. We just in many cases have to follow the process of finding the legal heirs also through
Yeah.
the revenue records, through Tahsildar office, through SDM Patwari office, where this hierarchy, this hereditary tree may be available. So some of the small towns there is this such facilities also
So
available there.
we also take help from the election electoral list, because see, in
Yes,
the
yes,
electoral list also we find, in case somebody is staying in the same house, so we normally
yes.
find that who are the other members in the family staying together. What are the other
This is the
difficulties,
issue.
Sanjay, that you can share?
Yes.
So tenancy is the other difficulty. So any experiences where we have resolved tenancy issues on a property and then we have been successful? Maybe we can share what can we do, especially for tenanted properties, and what is the way out for that? That is a popular
I have a
question. Then a popular. I'll just bring out some questions that are here. So
yeah.
another question is, what happens due to lockdown? Does everything get stayed? Does everyone get more time? Can the borrower now come to the court and say that that there was COVID and I was served a notice, but so the banks are asking that they were not able to respond within 15 days because of COVID happening. So what happens to those 15 days? Will they be extended by the lockdown period? So such questions are there.
Generally, I think one, that generally all the timelines provided in all the laws would stand extended because of the lockdown. And also there is a moratorium which has been provided through which High Court, Sanjay, given an order for 3 months moratorium, which further would be extended.
It was, I think, yesterday being declared by this RBI, I suppose.
RBI declared only.
It is now
No,
6 months now.
It is 6 months now, and I think the NPA would not be declared, and the SARFAESI action would not be taken. Any kind of timelines provided under the SARFAESI also would be extended. So this is the question, and even the I think it's like, I also know many borrowers, they also feel little relaxed and they feel relieved, because in case their account was up to very close to NPA, so they are also getting a breather for about 6 months, and which may even further get extended in case this situation doesn't improve. So that's very clear that this particular period of 3 months, 6 months would be totally excluded from the timelines, and it will not be considered as default or non-compliance.
I think we have Sanjeev ji online now. We also have Aditya online now. Maybe Aditya can share something.
Aditya, can you hear me?
Yes, sir. Good evening, sir.
Good evening, Aditya. So Aditya, you've been participating in this webinar right from the beginning. So there are various rules and various appendix and various amendments as actually which we have deliberated today. What are the practical experiences and hurdles that you feel that the borrowers are taking shelter? What are the biggest reasons that you have experienced, or what are the safeguards that you would suggest to all of us, to the bankers, for faster recovery under SARFAESI, based on your practical experiences?
मेरा जो अपना एक्सपीरियंस है उसमें जब हम सिंबॉलिक पोजीशन किसी प्रॉपर्टी पे जाके ले रहे हैं, तो अभी हमने ये देखा डीआरटी लखनऊ में केसेस में स्टे मिल जाता है। रीजन कि जो पोजीशन नोटिस है वो सेम डे डिस्पैच नहीं हुआ पार्टी को।
ओके,
सेम डे हमने उसको स्पीड पोस्ट नहीं किया है, उसको डिलीवर नहीं हुआ। इस वाली एक तो ये ग्राउंड है और कि वो डीआरटी में मूव कर जाते हैं। एक और मैंने देखा था 13(2) जब हम भेजते हैं बोरोवर्स को, तो उसमें एनपीए की डेट मिसिंग होती है। डेट ऑफ एनपीए डालना बहुत जरूरी है 13(2) के नोटिस के अंदर। मैंने कई सारे केसेस में 13(2) कई बार दोबारा भिजवाए गए हैं, तो बोरोवर उस पर भी जाता है कि इसमें एनपीए की डेट ही मेंशन नहीं है। आउटस्टैंडिंग अमाउंट, अभी किसी बोरोवर को एक से ज्यादा क्रेडिट फैसिलिटी दी हुई है, तो उसमें से वो छूट जाती है, 2 लिख दी, 1 छोड़ दी। आउटस्टैंडिंग उसमें प्रॉपर मेंशन नहीं है, ये प्रॉब्लम है। स्टार्टिंग में 32 में तो मेनली यही है कि हम टोटल ड्यूज अपने सही से नहीं लिख रहे हैं और एनपीए की डेट मिस कर रहे हैं। 13(4) के टाइम पर हम पोजीशन नोटिस को सेम डे डिस्पैच नहीं कर रहे हैं। ये 2 हर्डल हैं जो बार बार ये आ रही हैं।
So what Aditya Jain is sharing the experiences is like, while we take the symbolic possession or we take the physical possession and we don't serve the notice to the borrower within the same day, then the borrowers immediately file an application to DRT, and the DRT also obliges them by giving a stay, because the banks have not complied with one condition, and that condition is to give to service the notice whenever you take any physical possession or symbolic possession to the borrower. So this is one very important practical experience is shared by Aditya Jain. Secondly, what he says that when we issue section notices under 13(2), and some people, they don't mention even the date of classification of the account as NPA, and some people don't even mention the total outstanding account, because there may be 4 or 5 accounts and one of the account is missing out of the total amount. These are also the reasons that are taken by the borrowers for taking a stay from some DRTs who are little liberal, and also the advocates take this advantage of some little non-compliances by the banks. So anything else, Aditya Jain, in case you want to share?
Or we can move now, Mr. If Aditya wants to say something.
I think we can ask Sanjeev ji. Sanjeev ji is self-muted. Sanjeev ji, you can unmute yourself and maybe share your experience.
So Advocate Sanjeev Vittal, can you hear me?
Yes, sir.
Yes, Sanjeev ji, you're audible.
Sanjeev ji, now I can hear you. So see, you have a tremendous experience of taking physical possession, selling, taking symbolic possession, servicing of notices, and then selling of the assets. So you actually need to share some of the hurdles that you face and some of the safeguards that you would like to suggest. You also understand what all has already been spoken, so there is no need to repeat. But in case you can add some of the fresh points, that would be really very, very useful for everyone.
जी सर, 13(2) के नोटिस में बैंक के साथ में एक सबसे बड़ा इशू ये है, जो हम एडवाइस करते हैं कि इन केस ऑफ पार्टी एक्सकाउंट कर जाती है, कभी कभी पार्टी अवेलेबल नहीं है और उसने रेंटल ले रखा था प्रेमिसेस, उसका एड्रेस है, पार्टी एक्सकाउंटेड है, कहीं भी नहीं मिल रही है, तो बैंक को हम एडवाइस करते हैं कि 13(2) के नोटिस को पब्लिकेशन करा दीजिए 2 लीडिंग न्यूज़पेपर में। बट बैंक कहती है कि ना आप ट्रेस करो, तो वो एक ऐसा हर्डल है कि आप 6 महीने उसे ट्रेस करते हैं, तो 6 महीने ट्रेस करने के लिए निकाल देते हैं, तो उससे रिकवरी का प्रोसीजर पूरा हैम्पर हो जाता है, हो ही नहीं पाता, क्योंकि वो नोटिस सर्व नहीं होगा, आगे फर्दर कार्रवाई होगी नहीं। उसको प्रोसीजर को कराने के लिए बैंक से लगातार रिक्वेस्ट करते हैं और हम किसी भी चैनल पे किसी भी सिस्टम पे जाके बताने के लिए तैयार भी होते हैं कि आप लोग इस चीज को अर्लीस्ट पॉसिबल 60 डेज का नोटिस है, 60 डेज होने में ज्यादा टाइम नहीं लगता है। जिस दिन हमने डिलीवर किया उसकी एडवांस में हम रिक्वेस्ट भी करते हैं, एडवांस में हम रिपोर्टिंग कर देंगे, तैयारी कर देंगे, इन्वेस्टिगेट कर लेंगे कि पार्टी अवेलेबल है या नहीं, प्रॉपर्टी आइडेंटिफाई करा देंगे, वो सारा काम 13(2) के पहले ही हम लोग रेडी करा देते हैं, बैंक को पूरा बैकअप देते हैं हम कि 13(2) सर्व करने से पहले कि कोई भी 13(2) फेलियर ना हो बैंक का। एक ब्रांच के 40-30 नोटिस हम तैयार कराते हैं 13(2) के, बट बैंक कभी कभी ये रिक्वेस्ट नहीं फॉलो करती है। अल्टीमेटली क्या होता है, हैम्पर होता है आगे फर्दर स्टेज पे जाने के बाद।
So very good, Sanjeev ji. Like what Advocate Sanjeev Mittal has shared as one, that the whenever the party is absconding and it's not locatable, then the banks should rather than trying to serve the notice personally to the party, the banks should resort to the public notice and move on. If the asset is available, if the asset is sellable, then there is no point wasting months together for tracing the person, because the person is not important, asset is important. This is what is the feedback which has been given by the practical experience of Advocate Sanjeev Mittal. So Ankit, is there any other questions that we can attend, or I should actually complete now, because already there are this is about 6:23.
You can complete. The questions are too many. I don't think it's feasible to answer them all. We will have to compile them and maybe send in the answers separately. A lot of them must have already been answered, but a few of them who are not answered are, I think what I will do is, I think you can complete it. I will request those people whose questions have not answered and who are still relevant to ask them again. Maybe I can take some of them after you have spoken.
So it is the very important part that we would like to share here is the one which is the encumbrance part. I would like to say that there is a rule 9 sub rule 7, and this is a step 8. Whenever there is a sale which is complete, the purchaser would also see if there are encumbrances. This is a concept which is called like as is where is basis. When we sell some asset, as is where is basis. So there are some encumbrances on the immovable property, and those encumbrances could be some kind of workers due, some kind of an attachment, some kind of electricity dues, or some kind of attachment by any local authorities or statutory authorities. So there is a process provided under the SARFAESI Act where the purchaser has the option of depositing the money required for removal of these encumbrances with the authorized officer, along with the interest and along with some kind of additional amount required for handling these encumbrances. So in case the borrower decide to use the secured creditor for handling these encumbrances, then the secured creditor will do this, and after taking the money in advance from the purchaser, and in case it is done and later on whatever is the money which is left with the bankers in excess, that would be returned. Then in these cases, in case the purchaser decides to use the bank or authorized officer for removal of the encumbrances, then it is the duty of the authorized officer to hand over the property to the purchaser free from all encumbrances. Certificate of sale, whenever we issue certificate of sale, that specifically should mention whether the purchaser has purchased the property free from all encumbrances, or else whatever known encumbrances are, that should be mentioned. Whatever known encumbrances are, that should be mentioned in the certificate. So there is another concept of taking over management for under SARFAESI also, as I discussed in the first series, that this is not I'm going to repeat today, because the management taking over management of companies under SARFAESI has not been popular, because the banks are actually finding difficulties in how to appoint directors and how to run the business and how to do about the losses which is being run, how to handle employees or workmen, whereas in the IBC it has been completely provided, whereas under SARFAESI it is not provided. So we are not discussing this all that, since we are also delayed today. So the appointment of manager is also not discussed. This is 19, I believe. This Indian Overseas Bank authorized officer, Indian Overseas Bank versus Ashok Shah Mill. This is a Supreme Court judgment in which it was held that the provisions of Section 13 enable the secured creditors such as banks and financial institutions not only to take possession of the secured assets of the borrower, but also to take over the management of the business of the borrower, including the right to transfer by way of lease assignment or sale for realizing secured assets, subject to the conditions indicated in two private provisos to clause B of subsection 4 of section 13. To prevent misuse of wide powers, checks and balances introduced in section 17, which allows any person, including borrower, aggrieved by action taken under section 13(4) by secured creditor to make an application to DRT having jurisdiction in the matter within 45 days. See, then the another 2017 judgment in the case of MD Frozen Foods Export Private Limited versus Hero FinCorp Limited. In the event that the secured assets were insufficient to satisfy the debt, the secured creditor would proceed against the other assets in execution against the debtor after determination of the pending outstanding amount by a competent forum. So whenever the asset is sold, then there is a procedure under Rule 11 for the balance amount. An application can be made to DRT in Appendix 6 and of the rules. The Debt Recovery Tribunal procedure rules shall be applicable, and then finally the decree would be given by the DRT for recovery of the balance amount which has not been paid, which has not been settled after sale of the secured assets. Now this is the right to file applications, and this is basically the section 17 which has been used maximum by the borrowers, where the applications are being filed before the DRT by any person, including borrower, within 45 days of the action or measures taken. No application can be filed if the representation or objections are not accepted by the secured creditor. Jurisdiction lies at the cause of action, location of the asset, branch or other offices of the bank maintaining, because this also has actually seen a lot of litigation. Where is the jurisdiction? The DRT will consider if any measures have been taken without following the provisions. If found, then the order can be reversal can be confirmed. If found that some provisions are not complied with, then the measures taken would be reversed, and the important the action appeal to be disposed of within 16 days from the date of application, and the maximum time can be taken is 4 months. Of course, these timelines are not presently being adhered to. The appeal to debt recovery tribunal, debt recovery appellate tribunal is under section 18, and it is a very, very important part that we can see that for filing any appeal before DRAT, 50% of the debt due has to be deposited, and therefore most of the applications are going from DRT to high courts. And now, of course, a lot of high courts have started passing orders that you actually have to go back to DRAT, and the fees can be reduced by DRAT to the extent of 25% for the reasons recorded. For the so this has actually been a very big litigation reason, because the otherwise the payment of 25% or 50% becomes very difficult. So most of the litigation actually then it was moved to various high courts. The see the again, like it is a very recent judgment in the case of Union Bank of India versus Rajat Infrastructure Private Limited. It is dated March 2020, just before the lockdown. It says section 18 of the act, even if the amount or debt due had not been determined by the DRT, the appeal could not be entertained by a DRAT without insisting on pre-deposit. The third proviso enables the DRT for reasons to be recorded in writing to reduce the amount of deposit to not less than 25%. A grantor or a mortgager who had mortgaged its property to secure the repayment of the loan stands on the same footing as a borrower, and if he wants to file an appeal, he must comply with the terms of section 18 of the SARFAESI Act. So with this Supreme Court order, which is dated March 2020, I think the most of the application will move back to DRAT, and also the deposit of 25% would become mandatory, and it will reduce a lot of litigation, because this judgment is from Supreme Court, and I don't think no DRT or DRAT would disobey this order. So this is a very big achievement in SARFAESI law, and in fact various Supreme Court orders and High Court orders, I would say that it actually is a conclusive orders now, and in case the DRT capacity is augmented a little, the orders would come, the litigation would be reduced, and the recovery under SARFAESI would be much faster. The only condition is that there should be buyers available. So with all these litigations, as we have already said, that this SARFAESI, this act is also the filing of the registration we have already attended, and the priority of the secured creditor. This is section 26E of the SARFAESI Act, which says after the registration of security interest with CERSAI, the debt of the secured creditor, that is banks, financial institutions, NBFCs, ARCs, etc., shall be paid in priority over all other debts and all revenue, taxes, cesses, and other rates payable to central government or state government or local authority. If IBC proceedings are pending in respect of any secured asset, the priority of the secured creditor would be as per IBC. So based on this, I would like to conclude that the scenario is very positive for SARFAESI actions. Most of the disputed issues have already been settled by the Supreme Court. This is also one of the judgment which says that it's basically K. Virupaksha versus the state of Karnataka, and it is again March 2020. Supreme Court has held. The only issue before the Supreme Court was whether it is permissible to enforce contractual obligations by resorting to filing criminal complaints. Because I have seen the banks filing criminal complaints. Maybe the borrowers has taken away some of the property, mortgage property away from the company, and then there are criminal complaints are being filed. The Supreme Court has held that all actions taken by the banks are not to be treated as sacrosanct and can be questioned under the provisions of SARFAESI Act. The Supreme Court said that this is so when there exist discrepancies in which a bank has proceeded against a secured creditor, a secured debtor, and the debtor can assail the orders provided under the said law. See this, like again, we can go back to various other Supreme Court judgments also, but that's not what the time permits. We have already completed our presentation, and that presentation was primarily focusing on the reasons for delay in SARFAESI actions and recovery under SARFAESI Act, and also the safeguards. I think my team, my general manager, my associates have actually given a lot of tips, and the only thing that we have to say now, that in case IBC and SARFAESI would be the two remedies available with the banks to handle non-performing assets, to handle defaults. The other thing which is, of course, which is expected from the banks, in case the circumstances in the country would not improve or in the world would not improve, then it would be restructuring or a kind of bailout packages by the banks. So the SARFAESI law, as of now, is a well-settled law. The precautions that has to be taken by the banks has actually been provided in the rules. Each and every word of the rule has to be followed, and most of the litigation is on the procedure and processes. With this, we would like to conclude, and before I conclude, Advocate Sanjay Gupta would like to add something, or Ankit would like to add something.
Thank you,
So I
sir.
think,
You well said. Yes, Ankit.
Sanjay, please proceed.
No. Please.
So I think we will, of course, we can share that we have questions. We will try and answer them separately and send them separately to all the participants. We can also, I think, we can also perhaps, of course, we will share the YouTube link to this video to all the participants. And anything else that we would like to add?
Yes, Advocate Sanjay Gupta, in case you would like to add something. See, do you feel very positive about SARFAESI law?
Yes, sir, definitely. That's what I was just trying to conclude, that, as you said, the IBC and SARFAESI, that these two tools would be helpful in recovering the dues for the banks. I think court cases, as the tradition tells, that would take much time. DRT is also overburdened, and normal recovery suits are also taking much time. So in the normal scenario, IBC and SARFAESI is the only effective and left out tools which would be helpful. So I am very much hopeful and bullish about SARFAESI also.
So with this, we again thanks our most of the banker friends who actually participated in this webinar. And as we said in the morning, that this is focused on our banker friends who are associated in the recovery processes in the banks, ARCs, NBFCs. So we are thankful to each one of them for remaining connected with us for 2.5 hours. And we also would like to take their feedbacks in case they would be giving a feedback, and also would like to again say that this particular recording would be available on YouTube, and which is the YouTube channel by the name of AAA Insolvency, and it would be available. So in case you find any difficulty, please connect with us. And also, in case you have any other requirement, please connect with us. So with thanks to all, and thanks to all our team, we could conclude this webinar. Thank you very much.
Thank you,
Thank you,
sir.
everyone.
Thank you very much. Thank you, everyone. Thank you. Thanks a lot.